Then
the
he
boy
committed
committed
suicide.
suicide.
Yeah.
So, so for a while, what happened? The police did not file an FIR. This is what the father has been saying, and
Mhm.
investigation was also not done. Charge sheet wasn't filed, and according to me, this would have gone in abetment to suicide, which is cognizable. But
Mhm.
FIR was lodged under Section 67 of the IT Act, की defamatory statements थी,
Fine, fine,
and
fine.
then NHRC transferred it to CBCI. So in such a case, what can we as a lawyer do?
The when I discuss with you the decision of Sakiri Vasu, there I will be talking about in detail. But you have to go stepwise. So, for example, if you are approaching the police for lodging an FIR, and he refuses to do so, or she refuses to do so, whoever is in charge of police station, then second step is to write to superintendent of police. So suppose this case was of Gurgaon, then his father should have written to commissioner of police of Gurgaon, as Gurgaon is a commissionerate system. Second, if you do not get any remedy from the superintendent or commissioner of the police, then you can file a criminal complaint before the magistrate, and in that complaint you can request the magistrate to order the police to register a FIR under 156.3 of under 156.3 of CrPC. If then also you are not satisfied with the decision of the magistrate, if he declines to order the police to register an FIR, then you have two options. One is you can prefer a revision application before the sessions judge, or you can go to the High Court under 482, asking the High Court to intervene in this matter and order the police to register an FIR. So that is how you would move. Now, I do not know what had happened in that particular case, but yesterday ka case I can tell you that in Delhi riot case, a person, maybe some of you must have heard that particular news yesterday, that a session judge of in Delhi has imposed a fine of rupees 25,000 on Delhi police. So there the story was that there was a victim of Delhi riot. He lost his left eye during that brawl. So he went to the police station, tried to give them a written complaint against five accused persons, because he was alive and he had seen all of those five people, and asked them to register an FIR. Instead of registering his FIR, they clubbed that grievance also in one of the FIRs lodged by some other person. So against this, he filed a complaint before he wrote to Commissioner of Police, but there also he did not get any relief. Then as per CrPC, he went to the magistrate, Metropolitan Magistrate of Kadkad Duma, who is having the jurisdiction over that particular area. So their Metropolitan Magistrate ordered the police to register an FIR. Now, against that order of Metropolitan Magistrate, as such an order of ordering to register an FIR to police and conduct an investigation is a revisional order. So police went for revision before the Sessions Court. So yesterday's Sessions Court not only upheld the order of the Metropolitan Magistrate, but also asked the police to pay 25,000 rupees ka fine for their unprofessional behavior. And as I was telling you yesterday, that if a police officer does not register FIR under the provisions of CrPC after Lalita Kumari case, then you can file a criminal case under 166 of IPC against such errant police officer, and also write to his superiors to take a disciplinary action against that police officer, and you can simultaneously pursue a contempt proceeding against that particular police officer. So in his order, the session judge has also made it clear that the complainant the complainant in this particular case is free to prosecute the erring police officer, and also ordered the police to register an FIR. So that is how it will move. I do not know how that case reached up to NHRC, but it was a simple thing. You have to go stepwise. Go to the police. If they refuse, go to the SP or commissioner. If it is a superintendent system or commissionerate system, depending on that. Then if they do not register, then go to the Ilaka magistrate, ask, pray him to order the police register an FIR and investigate. if you are not getting your relief from magistrate also, then you can file 482 ka petition before the High Court. So that is how it will move. In every case, it will move like this. However, I tell you one or more things which were discussed by Justice Katju in that particular case, that what people do, that if the police refuses to file the FIR and SP also does not assist them, they directly go to the High Court under 482. So such things should not be done, because you have one more alternative remedy to approach magistrate. So everyone should try to approach magistrate if they have a grievance of non-registration of or refuse in the nature of refusal to register an FIR. Okay, so how that case reached to NHRC?
So the accused were very influential, and I guess nobody was filing an FIR.
Did they go to the magistrate? His father, the victim's
Yes.
father.
It's been 1 year. They did go there, but I don't think anything happened.
And then the best thing would have been to file a writ before Punjab and Haryana High Court.
All right, sir.
That would have been the best thing under 482.
I think the FIR was lodged. Now the investigation is again happening because police did not do it very well. So now it's gone to CBCID. That's
So
all I know.
that happened on the order of High Court or NHRC?
NHRC.
So please check it, because I have some doubts whether NHRC has the power to ask a particular agency to conduct an investigation. That power is vested in High Court and Supreme Court mainly.
Yes, I will. Thank you so much.
Fine. So we'll discuss it in once more. Please write this process stepwise somewhere. What you are required to do if you are a lawyer and your client is aggrieved of a particular situation, aggrieved in a particular situation wherein he or she approached the police station, but the police did not register his or her FIR. And this is more serious after Lalita Kumari decision, because you have a binding direction of the Supreme Court that it is mandatory for the police to register an FIR until and unless the case falls within any of the exceptions given in Lalita Kumari case of the MCC nature: matrimonial, commercial, medical negligence, corruption, and delay. So if the case is not related to any of these types, then it is mandatory for the police officer to register an FIR on an information which is disclosing a cognizable offense. So in Youth Bar Association, and it's a different kind of a litigation. I used to call it a time traveler litigation. Like, petitioner is trying to get a relief which is beneficial for people in general, but when that relief will be finally given to the petitioner, even the petitioner does not know how helpful or beneficial this is going to be at the implementation level. So actually what petitioner is trying to do is that he is getting a relief from a institution of the 21st century, but that relief is going to be implemented by a police machinery of the colonial times. So this decision has to actually time travel, and after that time travel, it can be said after looking at the entire travel of this decision up to the police station that is situated in the deepest part of our country, then only we can say how successful we had been in taking benefit out of such kind of a decision. So Youth Bar Association filed a writ petition under Article 32 of the Constitution before Supreme Court, asking the court to issue a writ of mandamus. Mandamus is issued by the court directing the government to do something or not to do something. For both purposes, mandamus can be issued. So when mandamus is issued कि भैया ये काम करो, तो इसका मतलब गवर्नमेंट को वो काम करना चाहिए था, but it is not doing. That is why now court is directing the government to do so. So petitioner is approaching the court and asking it to issue a writ of mandamus against Union of India and states to upload each and every FIR registered in all police stations within the territory of India in the official website of police of all states as early as possible, preferably within 24 hours from the time of registration. So, in simple words, the writ was asking the Supreme Court to order or to direct Union of India and all state governments that they should upload each and every FIR online within a period of 24 hours. You should upload a copy of FIR online within a period of 24 hours. A remedy which is very well knit into, or you can fit it into the rule of law or dynamics of 21st century, wherein you are integrating information technology, communication and ICT communication technology with the justice delivery system. It's a very good thing that if you are asking the court to direct government to upload a copy of FIR within 24 hours, FIR registered in any police station online within 24 hours, then you are actually taking help of ICT to make the criminal justice system better. Now we are not much concerned with what are the arguments given by the petitioner to convince the court that they should issue the direction of such nature. We may look at them once we are thorough with the direction, but we will directly jump to the direction given by the Supreme Court. So Supreme Court accepted this plea of petitioner and issued a certain direction wherein it directed the Union of India and state government to upload a copy of every FIR registered in any police station throughout the territory of India online within 24 hours. However, when you read all the directions, then they have also created certain exceptions. That if the FIR is related to a case of sensitive nature, for example, if it is relating to a case involving terrorist activities, if it is relating to the case involving sexual offenses, and wherein privacy of the victim is required to be protected, so then the state authorities could decide, including police could decide, whether to upload the FIR or not to upload the FIR. But except the cases which are of sensitive in nature, police is under an obligation to upload the FIR within 24 hours and at max 48 hours if there is a connectivity problem and the police station is situated in deeper areas, or that period could go up to 72 hours. So by and large, the crux of the petition was accepted by the Supreme Court, and Supreme Court issued comprehensive direction relating to availability of FIR, easy availability of FIR, not only to the accused person, but to any person who wants to have an access to the copy of an FIR in any case. That is why it is a common scene nowadays कि जब भी कोई FIR फाइल होती है तो उसकी कॉपी हर एक टीवी चैनल पे फ्लैश करने लगती है. It's because you have to create an account, I guess, on CCTNS something network or a state police ka website, and there you can put the number of the FIR and download the copy of FIR. That is why you would see that nowadays on various media platform, people are reading directly from the FIR. If it is like politically sensitive case or it's a sensitive case about which people are talking about, then you will see many people reading from the extracts of the FIR. So it is because of this decision given in 2016. Now coming to discuss the direction one by one. Now, a problematic part of CrPC and it is up to the person who is looking at the CrPC. I guess one of you either in this class or in section I asked me that when will accused get the copy of the FIR. So the answer under CrPC is that accused is entitled as a matter of right. Entitled means as a matter of right. Accused will get a copy of the FIR when his case is sent for trial to the session judge, or when magistrate decides after taking cognizance to issue the process and try him or her, whoever is the accused. So as per section 207, he will get the copy of the FIR at that stage. तो कितनी स्टेज क्रॉस हो गई? Registration of FIR, the entire investigation, then cognizance का stage, and then issue of process का stage. And after the issue of process, accused will get a copy of FIR as a matter of right. However, इससे पहले accused को bail के लिए भी फाइल करना होता है. इस स्टेज के पहले, इससे पहले accused could file a 482 का petition for quashing of FIR. इससे पहले शायद accused may file a petition for quashing the investigation or has some grievance relating to investigation that it has not been conducted fairly. इससे पहले accused could approach the appropriate courts for quashing the charges framed against him. So the entire idea of supplying a copy to the accused person under 207 after the stage of issuance of process and just before the stage of framing of charge does not seem to be very reasonable. That is why earlier also, before this decision of uploading a copy of the FIR, what you need to do is you have to ask for the certified copy of the FIR, and you can do that either by writing to the police or by writing to किसके पास कॉपी है FIR की एक और पुलिस के अलावा? मैजिस्ट्रेट. ठीक है जी. या तो आप पुलिस को लिख के मांग लो कॉपी, सर्टिफाइड कॉपी ऑफ द FIR, या मैजिस्ट्रेट को लिख के मांग लो. इफ यू आर नीडिंग इट, आप उसमें मेंशन कर दो आई नीड इट फॉर बेल पर्पसेस, आई नीड टू फाइल अ पिटीशन बिफोर द हाई कोर्ट फॉर क्वेश्चनिंग द FIR, या फिर मुझे इन्वेस्टिगेशन से रिलेटेड ग्रीवेंस के लिए कोर्ट जाना है, या फिर मैजिस्ट्रेट के सामने ही मुझे इन्वेस्टिगेशन रिलेटेड ग्रीवेंसेस के लिए 156(3) में ऑर्डर लेना है. सो देन यू कैन गेट अ कॉपी ऑफ द FIR. So the same direction has been reiterated by the Supreme Court. An accused who has reason to suspect that he has been robbed in criminal case and his name may be finding a place in FIR can submit an application through his representative, agent or perukar for grant of a certified copy before the concerned police officer or to the SP on payment of such fees which is payable for obtaining such a copy from the court. On such application being made, the copy shall be supplied within 24 hours. So here we have got a direction, जो चीज पहले भी होती थी, but it was not done, or it was not being done by the police or the magistrate as per the decision of the highest court. And now it has been made super clear by the Supreme Court. अगर आपको भी ये कंफ्यूजन हो कि एक्यूज्ड को कब FIR की कॉपी मिलेगी और कैसे FIR की कॉपी मिलेगी, तो इसके लिए यू शुड रीड द डायरेक्शन नंबर 2 ऑफ यूथ बार एसोसिएशन केस. You give an application to the police officer in charge of the police station, or you can give an application to the superintendent of police having jurisdiction on the police station in which FIR has been registered, and a copy shall be supplied to you within 24 hours. Now next is, you have an alternative way also, because every FIR which is registered by the police, a copy of it is sent to the magistrate as per provisions of section 157. So therefore, once the FIR is forwarded by the police to concerned magistrate or any special judge on an application being filed for certified copy on behalf of the accused, the same shall be given by the court concerned within 2 working days. So the only difference under direction number 3 is wherein you are getting a copy of the FIR by filing an application, that it will be supplied to you within 2 working days. Police is under an obligation to supply to you copy of the FIR within 24 hours. The aforesaid direction has nothing to do with the statutory mandate in head under 207. So that is true, because 207 is a provision wherein, if you read it, accused is entitled. When you are entitled, which means you don't have to apply for that thing. You don't have to ask. When you are entitled, when you have a right, it is the duty of someone, because the correlative of right is duty. So if you have a right, if accused has a right to get the copy at the stage of the section 207, then it is the duty of the court to supply copy of the FIR to the accused person. तो वहां पे तो उसको मिलनी है copy of the FIR. But this decision is more concerned about what if accused or any other person needs a copy of the FIR before section 207. Now next is, and which is the crux of the petition, because of which petition has been filed. The copies of FIR, unless the offense is sensitive in nature. So in all cases except offenses relating to sexual offenses, offenses pertaining to insurgency, terrorism, or that category, offenses under POCSO Act, and such other offenses should be uploaded on the police website. This was the relief for which a petition was filed by Youth Bar Association, and it was granted with the rider that yes, we agree, and we are directing the government to upload copy of the FIR on the website, except in cases of sensitive nature. Except in cases of sensitive nature. Now, court is saying, and this is court. That is why I say that these are time travelers' decision. Court is sitting in Delhi. It's the highest court of India, so it is operating in a 21st century framework. But it is also aware of this fact that the entire country is not operating in 21st century. Some areas of India are in 1980s, some areas of India are in 1950s, some may be in 1910, or some may be before, in the 18th century also, later half of 18th century also. The things which were the creation of that era are still being used in that part of the country. So court is also aware about it. Sometimes it lose sight of this fact, but it should not. That is why it said that if there is no website of the police, then you must upload the copy of the FIR on the official website of the state government within 24 hours of the registration of the FIR, so that accused or any person connected with the same can download the FIR and file appropriate application before the court as per law for redressal of his grievance. For example, bail, quashing of FIR, या फिर उसके अलावा कोई आपको relief चाहिए हो court से, so that you can easily do that. It may be clarified. Now it is talking more about situation throughout the country. It may be clarified that in case there is a connectivity problem, yes, you have to take care of this fact, because till the time you do not recognize that in the same country people are living in different eras. कोई 1890 में रह रहा है, कोई 1950 में रह रहा है, कोई 1940 में रह रहा है, कोई 1970 में रह रहा है. So you won't be able to streamline your decision if you do not realize this fact. So court is realizing this fact and trying to streamline its decision or limit of 24 hours, keeping in mind the conditions in different parts of the country. That if there is a connectivity problem due to geographical location, or there is some other unavoidable difficulty, the time can be extended up to 48 hours. The said 48 hours can be extended maximum up to 72 hours. And it is only relatable to connectivity problem due to geographical location. So court said that there is only one excuse of breaching that limit of 24 hours and not uploading the copy of FIR on official website within that period. And that is that if there is a connection problem in a particular area, in a particular geographical location, if there is a internet connectivity problem, then you can upload the copy of the FIR either within 48 hours or at max 72 hours. So at max, police has 72 hours to upload the copy of the FIR in those cases where there is a connectivity problem, and that is a kind of a serious problem. जब देश के कुछ थानों में बिजली चली जाती है 8-10 घंटे के लिए, तो कनेक्टिविटी प्रॉब्लम रह सकती है. मतलब इट्स नॉट अ बिग डील कि कनेक्टिविटी प्रॉब्लम ना हो. सो दिस direction number D was the crux of the petition. इसके पहले जो कहा वो होता हुआ आ रहा है, but for the first time Supreme Court is clarifying it and putting a time limit on it. You can get a copy of the FIR from police, and police is under a duty to supply that copy within 24 hours. You can get a copy of the FIR from the magistrate also, and magistrate is duty bound or court is duty bound to supply the copy of the FIR within 2 working days. 2 working days, not 2 regular days. They must be 2 working days. Next is that the decision. Now it is talking about what is meant by like how this exception of not uploading FIR in sensitive cases would actually pan out. So they are telling in brief the procedure as well. Who will make the decision? How the decision can be made? Can you challenge this decision of not uploading the FIR by the police on this ground that it is a matter of sensitive nature? And there they are saying under E and D that the decision not to upload the copy of FIR on the website shall not be taken by an officer below the rank of Deputy Superintendent of Police. So this is the first safeguard or procedural safeguard which they have introduced कि कोई FIR का nature sensitive है या नहीं है, इसका जो final decision है it will be taken by the officer of a particular rank, and any officer below that rank is not entitled to take that decision. In cases the state where district magistrate has a role to play, he may also assume the said authority. So a decision taken by the concerned police officer or DM shall be duly communicated to the concerned judicial magistrate. And this is the second safeguard. First is only a officer of a particular rank, either DSP or district magistrate as the case may be, जो भी state government notify करे that this person is the appointment to decide whether an FIR should be uploaded or not uploaded on the basis of its nature, whether it is a sensitive nature ka FIR or not. So the second safeguard is that in case this appointment person, either DSP or DM, they are deciding not to upload the FIR on the ground provided by the Supreme Court, then they have to communicate this, that we have not uploaded FIR number 2 of 2021, 50 of 2021. These 2 FIRs were not uploaded on the official website because of the kind of offenses mentioned therein. As they were sensitive in nature, we did not upload them. In case a copy, this I will discuss with you maybe at the time of, but the idea here is कि अगर FIR की copy upload नहीं होती है, then it will not be treated to be a ground to get anticipatory bail. ये मतलब है इसका जो written portion है, but I do not intend to discuss it right now because I haven't discussed with you the concept of anticipatory bail under 430 out of CrPC. But the main point which the court is saying कि ऐसा नहीं होगा कि एक्यूज्ड कोर्ट में जब एंटिसिपेटरी बेल फाइल करे तो उसका ग्राउंड ये हो कि पुलिस ने कॉपी ऑफ एफआईआर अपलोड नहीं करी, इसलिए गिव मी एंटिसिपेटरी बेल. सो within 24 hours police did not upload the copy, or within 72 hours if there is a connectivity problem, and that is why give me anticipatory bail. So that is not how it will work. The only idea behind asking the police to upload a copy of the FIR is to make it available to the accused person. If they are unable to upload it, then accused is not going to get relief in the nature of anticipatory bail because of that particular laxity of the police. In case copy of the FIR is not provided on the ground of sensitive nature of the case, a person aggrieved by the said action after disclosing his identity can submit a representation to SP or any person holding equivalent post. The SP shall constitute a committee of 3 officers which shall deal with the said grievance. So this is a further safeguard if copy is not uploaded. If suppose copy is not uploaded and you are an aggrieved person, you are the accused, and you want that copy should have been uploaded on the police portal or state government website, then you can apply or write an application to the SP that I have the grievance of XYZ nature that you did not upload copy of the FIR on the official website as per the decision of the Supreme Court in Youth Bar Association. So therefore, I request you to please look into this matter. In that case, that officer could constitute a committee of 3 officers who will look into the said grievance. The committee of 3 members, 3-member committee, shall look into this matter and dispose this off within a period of 3 days from the date of the representation and communicated to the aggrieved person. The competent authority referred herein above shall constitute the committee as directed herein above within 8 weeks from today. So court has also directed that the committee who is going to hear the grievance against those cases wherein FIR was not uploaded, as according to the DSP or DM, it involves an offense of sensitive nature. So to deal with such a grievance, we are directing each and every state and central government to ask its officers to constitute such a committee who would look into such grievance within 8 weeks from the date of this decision. In cases where decisions have been taken not to give FIR, तो ऐसा नहीं है कि अगर if you have taken a decision not to upload the copy of the FIR on the website, you will not give it to the accused as well. ऐसा कुछ नहीं है. So both these facets of providing a copy or making available a copy of the FIR to the accused or general public have different procedures and they are applicable differently. So as far as this direction relating to uploading a copy of the FIR within 24 hours or at max 72 hours is concerned, it is a different kind of direction, having a different nature. So you are trying to make justice more accessible, more transparent by asking the police to upload the copy of FIR within 24 hours. And it will benefit the accused as well and accused family members as well, and also members of the society in general. If media house wants to access a copy of the FIR, if you are a researcher, you wants to have an access of copies of the FIR which are filed in relation to a particular case. You are doing certain research on the contents of FIR in a particular offense, or kinds of FIR which are filed in different police stations throughout the country. So it will help all the people, all the members of the society, including the accused person. But in this situation, police has a discretion or state has a discretion not to upload the copy of the FIR, provided they satisfy the sensitive nature wala requirement. And there also the agreed person can approach the SP by writing an application, and he has to dispose of that application via 3 members committee constituted by SP within 8 weeks from the date of this decision. So there is a procedure for that. If you do not upload, then also there is a further procedure provided a person is aggrieved. But if suppose a FIR is not uploaded and nobody is aggrieved with such act of the state or police, but at the same time not uploading an FIR on the police website or state website does not mean that you are also not required to give it to the accused person when the accused person files for getting a certified copy of such an FIR. So court is making it clear. So do not think that if taking the help of the exception which we have created here for not uploading the copy of the FIR, please do not think you are also kind of immune from not providing a copy of the FIR to the accused person. Accused person can get a copy of the FIR in any case. The exception would be applicable only in relation to uploading the copy of the FIR on a public portal for public access. So in cases where decisions have taken not to give copies of the FIR, regard had to the sensitive nature of the case, it will be open to the accused, his authorized representative, to file an application for grant of certified copy before the court to which the FIR has been sent, and the same shall be provided in quiet promptitude by the concerned court not beyond 3 days of the submission of the application. So if police has taken a decision that we will not upload this copy of the FIR online and we will not provide the copy because the case is of sensitive nature. So koi embargo nahi hai on the accused that he cannot get the copy of the FIR. It's just as per this direction, the procedure is different. The accused can approach the Ilaka magistrate, file an application to get a certified copy of the FIR, and within 3 days of submission of such application, copy of the FIR shall be uploaded shall be provided to the accused person. It's just that this copy is not uploaded online for public access. The direction for uploading FIR on website of all states shall be given effect from 15th November 2016, and court is finally disposing of this particular case law by giving these directions. So now if suppose I want to know from you that can you get access of copies of FIR via online? As per this direction, I think you must be getting an access because it's a decision of 2016. So please find out from where you can download a copy of the FIR. I guess on CCTA, even if you make a account of CCTNS also, you can get a copy of the FIR, or you can go to the respective police website of different state ka police and make an account there. You have to make an account for that purpose, and then you can access a copy of the FIR. So if you have any question on this particular case law, you can go ahead and ask. Then we will move on to discuss the next case law. So the importance of such kind of a decision is to make criminal justice system more transparent, especially at the stage of filing of FIR. You can compare this decision with DK Basu case, which was trying to make the system criminal justice system more transparent, and was trying to fix the liability of the police officer while they exercise their power to arrest a person under CrPC. So you are cementing CrPC with the help of such decisions. You are cementing CrPC. So please look into it, that whether this decision has traveled to all the parts of the country successfully, or it is already at the stage of traveling. Not only this, there are many decisions which are time traveler in nature. They have to actually travel. So recently you must have heard police is still filing case under 66 capital A. So why is it happening? Because decision has not yet completed its travel journey from Supreme Court to different parts of the country, to all the police stations of the country. It is still traveling. There is a time gap between where Supreme Court resides and operates and where our police stations resides and operates. There is a huge time gap. So a police thana in Jalon and Sonbhadra maybe in 1950s or 60s, and a police thana in some parts of Abujmad or Bastar is in 1920s or 1930s, operating in that particular era. So decisions take time to travel from Supreme Court to different parts of the country. That is why Supreme Court is like crying like a baby that why you are filing case under a provision which has been declared unconstitutional. Section 66 capital A of IT Act. Why are you doing that? Even judges are granting bail, or magistrates are accepting charge sheet and taking cognizance, even after the section has already been declared unconstitutional. Now, I'll ask you to read 155 so that we don't have to read it again. So 155 is a provision which provides a procedure or which provides of the legal consequences that would flow in case a non-cognizable case offense has been committed. So this I told you in one of my lectures, and this is one way of reporting a crime, that when an information is given to the officer in charge of police station of the commission of a non-cognizable offense, then he will not register FIR, rather he will enter the substance of the information in the general diary and refer the informant to the magistrate. This is 155(1). I don't think you will face any kind of problem in understanding this particular provision. Okay? And second is, no police officer shall investigate a non-cognizable case. This we discussed when we discussed the difference between cognizable and non-cognizable cases or offenses. So there we discussed that the difference between cognizable and non-cognizable can also be understood on the basis of power of police to investigate a case. If it is a cognizable offense, then police has the power to investigate the case as a matter of right under 156. But if it is a non-cognizable offense, then no police officer shall investigate a non-cognizable case without the order of the magistrate. So police officer can only investigate a non-cognizable offense if there is a order in this regard passed by the magistrate, who has the power to try or to commit such case for trial. And third is, any police officer who is receiving such an order, like any police officer who is receiving an order under 155(2) for investigating a cognizable case, that police officer can exercise all the powers which he could exercise had it been a cognizable case, except the power of arrest without warrant. Power of arrest without warrant. So once an order has been passed by the magistrate asking the police officer to investigate a non-cognizable offense or to start an investigation in non-cognizable offense, police officer under 155(3), it would have all the powers that he would have been enjoying had it been a case involving a cognizable offense. So therefore 1, 2, 3 are making or drawing a clear picture for you, which is that no FIR shall be registered in a non-cognizable case. That is number 1. Number 2, no investigation can be initiated by the police officer without the order of the magistrate in a non-cognizable case. And third, no arrest can be made without warrant in a non-cognizable case in any situation, even when police is investigating the case on the order of the magistrate. So these are the points that are being made clear to the reader of CRPC कि भाई नॉन कॉग्निजेबल के केस में ये कुछ थंब रूल है. फर्स्ट इज नो नीड टू रजिस्टर एन एफआईआर. नो एफआईआर शैल बी रजिस्टर्ड इन ए नॉन कॉग्निजेबल केस. इसका मतलब फिर क्या होगा? क्रिमिनल कंप्लेंट होगी. ठीक है. नो इन्वेस्टिगेशन बाय पुलिस विदाउट द ऑर्डर ऑफ द मैजिस्ट्रेट. And number third, no arrest by police without warrant. No arrest by the police without warrant. However, there is one more provision. And the next case which we will discuss relates to this provision. Where a case relates to 2 or more offenses of which at least one is cognizable, the case shall be deemed to be a cognizable case. And when the case shall be deemed to be a cognizable case, what will happen? Anyone? ध्यान से पढ़ो इसको एक बार. Where a case relates to 2 or more offenses, जिसमें कोई एक cognizable है, कोई एक, at least one से काम चल जाएगा. एक से ज्यादा भी हो सकते हैं. Suppose the case involves 3 offenses and 2 are cognizable, 1 is non-cognizable, then it shall be deemed to be a cognizable case. If suppose there is 1 cognizable offense involved in the case and 2 non-cognizable, then also it shall be deemed to be a cognizable case. If it will be deemed to be a cognizable case, then what will happen? Anyone? भाई बताओ. If it is deemed to be a cognizable case,
FIR is mandatory, sir.
ठीक है. और उसके अलावा क्या हो सकता है?
Arrest could be made without warrant.
वारंट. उसके अलावा क्या हो सकता है? इन्वेस्टिगेशन हो सकती है. ठीक है जी. तीनों चीजें हो सकती हैं. नाउ वी विल रीड द नेक्स्ट डिसीजन. आप कभी भी ये सोच के लॉ मत पढ़ना कि भाई हम हाई कोर्ट के जो जजेस होते हैं उनको कुछ अलग से लॉ आता है और वो सीआरपीसी के बाहर से लॉ पढ़ते हैं, या कोई अच्छा एडवोकेट होता है वो सीआरपीसी के बाहर से लॉ पढ़ता है. ठीक है. तो दैट इज व्हाई यू शुड रीड डिसीजंस लाइक स्टेट ऑफ ओडिशा एंड शरद चंद्र साहू to feel confident about this fact that if this person can do it this way, then I can do it my way. So there is not a hard and fast rule of looking at somebody with awe कि भैया अच्छा ये तो शायद सीआरपीसी के बाहर से कुछ पढ़ता होगा तो शायद इसी की वजह से he has been such a successful lawyer, such a successful judge. ठीक है? So I'll tell you facts of this case and then we can discuss the decision in 1 or 2 minutes. Respondent 1 is the husband of respondent 2. Now in this case a wife wrote to the women's commission. Wife wrote to the women's commission against her husband that my husband has contracted a second marriage. पहला तो अपराध इसने ये कर दिया. दूसरा, he is also mistreating me and committing cruelty against me by asking for dowry, by demanding money from me. Now the women commission sent that complaint to police station where an FIR was registered against the husband, respondent number 1, FIR number 418 of 1993. हर एक FIR का ऐसा ही नंबर होता है, 1 2 3 में से कोई भी नंबर ऑफ द ईयर, जिस भी ईयर की होती है, क्योंकि FIR बुक में मेंटेन करना पड़ता है ना आपको वो. Now if an FIR has been registered, then police investigated the case, filed a charge sheet before sub-divisional judicial magistrate, a kind of an equivalent to magistrate first class, ACJM. You can call him ACJM as well, who after perusal of the charge sheet framed charges against 498 capital A, which is cruelty, and 494, which has been declared, I guess, it's bigamy. Is it bigamy or something like this? 494. So forget it. That's for you to decide. Now what happened that if you are aggrieved by framing of charges, if you are aggrieved, you are an accused person and you are aggrieved by framing of charges against you by the trial court, then you are entitled to approach high court under 482. जैसे क्वेश्चन ऑफ FIR के लिए you can approach the high court, ऐसे ही if you have any grievance relating to framing of charges, कि भाई गलत चार्ज फ्रेम कर दिए मेरे अगेंस्ट में, सिंपल भाषा में, more we will discuss when we will discuss charge, you can approach the high court under 482 asking it to quash the charges framed against the aggrieved person or against the accused person. So aggrieved by the framing of charge, husband approached the high court under section 482 for quashing the proceedings and charges framed against him. Now look at the decision of the high court. Keep in mind 155(4). The high court, ध्यान से पढ़ना इसको, the high court by its impugned judgment dated 3/5/1995 partly allowed the petition with the finding that since respondent 2 had not herself personally filed the complaint under 494, its cognizance could not have been taken by the magistrate in view of the provisions of section 198(1)(c). Consequently, the charges framed by the magistrate under section 194 IPC was quashed, but the charge under section 498 capital A was maintained, and the petition under section 482 of Criminal Procedure Code to that extent was dismissed. So the decision of the High Court is that there is a provision in CrPC 198 which talks about cognizance in offenses relating to marriage. तो वहां पे ये लिखा हुआ है कि अगर मैरिज से रिलेटेड कोई ऑफेंस कमिट हुआ है बाय ईदर ऑफ द स्पाउसेस, देन द कंप्लेंट हैज टू बी मेड बाय द कंप्लेंट बिफोर द मैजिस्ट्रेट हैज टू बी मेड बाय द अग्रीव्ड स्पाउस. तो वाइफ को कंप्लेंट फाइल करनी है अगर उसको बाइगमी वाला कोई ऑफेंस से ग्रीवेंस है अगेंस्ट द हस्बैंड. यहाँ पे क्या हुआ है अकॉर्डिंग टू ओडिशा हाई कोर्ट कि वाइफ रोट टू कमीशन एंड कमीशन आस्क्ड द पुलिस टू रजिस्टर ए केस, asked the police or filed a complaint to the police station to register a case. Moreover, this 494 is a non-cognizable case. It is not a cognizable case of that nature which should be tried by which should be dealt by the police and investigated by the police. Now this case has boiled down to a situation wherein the case involves a cognizable offense and a non-cognizable offense. So whether what was done by the police by investigating and filing the charge sheet was correct as per the provisions of CrPC, or do you think that the decision of the High Court is correct? Decision of the High Court is correct. So now you can decide on your own by reading 155 what is going to be the decision of the Supreme Court. Anyone of you, if you wants to try out that what should be the decision of the Supreme Court?
It should be cognizable offense.
It should be treated to be a cognizable offense. So therefore, all the requirements that were associated with offenses against marriage, had it not been clubbed with 498A, are not required to be satisfied as per the provisions of CRPC. जैसे ही आपने एक भी कॉग्निजेबल ऑफेंस क्लब कर दिया, अगर 5 नॉन कॉग्निजेबल ऑफेंस भी है, ऐसे पूरा केस वुड बिकम अ कॉग्निजेबल केस. Pura case would become a cognizable case, and you cannot take this plea that the magistrate cannot file charges, cannot frame charges against me on the basis of a police report. Because police report is filed only after filing of FIR and investigation, and that could happen only in a cognizable case. And XYZ charge has been framed against me, which is in relation to a non-cognizable case. Or if suppose there is any other requirement like taking cognizance only on the complaint of the wife. अच्छा, अगर मैं आपसे ये पूछूं कि ये सिर्फ अगर 494 का केस होता, then what would have been the situation? अगर सिर्फ then the grievance of the aggrieved person was justified. क्योंकि ये पूरा केस ही फिर नॉन कॉग्निजेबल होता, तो आपको 198 भी फॉलो करना पड़ता, दैट कॉग्निजेंस शैल बी टेकन ओनली ऑन द कंप्लेंट ऑफ द वाइफ, और आपको वो वाला प्रोविजन भी फॉलो करना पड़ता व्हिच सेज दैट पुलिस कैन नॉट रजिस्टर एफआईआर, कैन नॉट कंडक्ट इन्वेस्टिगेशन एंड कैन नॉट फाइल चार्जशीट इफ द केस इज ए कॉग्निजेबल नॉन कॉग्निजेबल केस, if the case is a non cognizable case. So here High Court could not study clearly what was provided under 155. So that decision was declared erroneous and appeal was allowed. So as far as the decision of the High Court was related to quashing the charge filed under 494, it was declared null and void, and Supreme Court held that magistrate should conduct the trial expeditiously on the charges framed by him. So these are some cases which you should read, and you should eagerly read. आपको पता तो चलेगा ना कि जो हाई कोर्ट में डिसाइड हो रहा है ना, that person is reading CRPC only, and that too incorrectly. So what if a high court judge can read CRPC incorrectly? I can to always do so in my initial careers or in my initial days of reading CRPC. I am also entitled to read CRPC not correctly. So this will give you a confidence that this code is not that difficult to understand. Is not that difficult to understand. Suhasini Mishra, Mansi, Sahil, Rajesh, Meenakshi. Meenakshi present, Rajesh present, Meenakshi present, Suhasini present, Sahil present, Aditya, Kritika, Vishwajit, Kritika present, Vishwajit present, Mayank, Ashish, Manvi, Naman, Ashish present, Manvi present, Naman present, Lavanya, Arshad, Karthik, Arshad present, Karthik, Anupam, Abhilash, Siddharth, Prerna, Siddharth present, Karthik present, अंजलि. किसी को अगर पूछना होगा ना तो क्लास के बाद पूछ लेना, बिकॉज आई हैव नो क्लास आफ्टर इट. अंजलि, राहुल, अरविंद, राहुल प्रेजेंट, अरविंद, सृष्टि, आशीष, सृष्टि प्रेजेंट, आशीष, सिद्धार्थ, सनी, वंशिका, अमन, सृष्टि प्रेजेंट, वंशिका प्रेजेंट, अमन प्रेजेंट, रामकरण प्रेजेंट, अभिमन्यु 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 प्रेजेंट, साक्षी, कुणाल, नितेश, नांसी, साक्षी प्रेजेंट, कुणाल प्रेजेंट, नितेश प्रेजेंट, नांसी प्रेजेंट, महेश महेश प्रेजेंट, अनुज अनुज, शिवांशु, सतपाल, विशाल, मनीष, सतपाल प्रेजेंट, विशाल, मनीष, पीयूष, कार्तिक, ज्योति, ज्योति प्रेजेंट, कार्तिक प्रेजेंट, राजेश, यास्मीन, राकेश, यास्मीन प्रेजेंट, राकेश, शुभम, मेघा, रमन, मेघा प्रेजेंट, रमन, गौरव, ओजस्वी, मनीष, ओजस्वी प्रेजेंट, मनीष, भूपेंद्र, कासिम, हरिप्रकाश, आकाश, आकाश प्रेजेंट, भास्कर, अंजलि, अजय कुमार, भास्कर प्रेजेंट, अंजलि, अजय कुमार प्रेजेंट, हिमांशु प्रेजेंट, स्वरूप प्रेजेंट, विनय, उषा, विनय प्रेजेंट, उषा, शौर्य, सुशील, सुशील प्रेजेंट, प्रतीक प्रेजेंट, रोल नंबर 815, 815 प्रेजेंट, वासुम, वासुम प्रेजेंट, तुलौन, अमृता, तुलौन प्रेजेंट, अमृता प्रेजेंट, रोहित, अमन, एक सेकंड सॉरी, एक सेकंड रुक जाओ, अमन, कुमार गौरव, उदय कुमार, कुमार गौरव प्रेजेंट, शौर्य प्रेजेंट, अभिलाष आपका रोल नंबर क्या है
सर? 2015
लास्ट वाला बताओ,
सर। जस्ट
लास्ट 3 डिजिट, अभिलाष लास्ट 3 डिजिट, आशीष एक सेकंड, आशीष नेगी, अपना रोल नंबर लिख दो आशीष एक बार, फिर इट वुड बी इजी फॉर मी टू मार्क योर अटेंडेंस। So we will have a scheduled class tomorrow, which is at 4:45. अभिमन्यु ये रिकॉर्डिंग बंद कर देना
सर। 15 है।
15 लास्ट में 15 है।
हाँ जी सर।
015 इसका मतलब
सर 204215 है।
215 है। 215
यस सर।
ठीक है ठीक है ठीक है अभिलाष,
थैंक यू सर।
और ये 073 6073 ये तो नहीं है यार नंबर आशीष, कुछ लास्ट की 3 डिजिट वाला नंबर बताओ। 073 तो नहीं है इसमें, इसमें तो 071 है और 083 है। आशीष नेगी 299, पता नहीं आप आशीष नेगी हो या कोई और ही आया हुआ। आशीष नेगी का रोल नंबर इज 204299। सिद्धार्थ, आई मार्क इट सिद्धार्थ। ठीक, ओके, थैंक यू सो मच भाई।